Good evening and welcome to RFL. I'm Richard French. The Derek Chauvin trial, it has wrapped for the day as week 2 continues. Today, the focus, it was on officer training and whether or not Chauvin followed procedures when he restrained Floyd with his knee on Floyd's neck for more than 9 minutes, as the world has now seen. In a minute, we will be speaking with a former Chicago police officer who's now an attorney who defends cops. Also, as the investigation into the Capitol riot continues, we're going to show you the high-tech surveillance techniques that the FBI is using to catch the bad guys. They're working, and that's good, but they're also revealing some really concerning issues when it comes to privacy. Issues that advocates regarding privacy have said are really concerning because it revolves around the tracking technologies that have become more and more effective as well as invasive, all without a national debate. Plus, as the race when it comes to vaccinations continue to soar, people are starting to go out more, travel, socialize, and we're looking to maybe get back to some normalcy. Could we be looking at another roaring 20s? We'll discuss and debate that coming up. But we begin tonight in Minneapolis in day 7 of the Chauvin trial. Now, it kicked off early this morning with George Floyd's friend, Maurice Hall, the man who was in the car with Floyd when he was arrested. Hall, he's been subpoenaed to testify, and the defense is more than likely planning to ask him questions about drugs and also the fake 20 Floyd that he passed at the convenience store that led to his arrest and inevitably that tragedy. But Hall's attorney says that he was planning to invoke the Fifth Amendment to avoid incriminating himself, so the judge ordered Chauvin's attorneys to submit questions they will ask Hall, and then it'll be revisited whether or not he'll be able to testify on Thursday. Now, once the testimony finally got underway, the focus, as I mentioned, was on training that Chauvin received and whether or not his pinning of Floyd was in line with police procedures. Minneapolis PD and the lieutenant who trains the officers there, including Chauvin, says what Chauvin did to Floyd is not in any manual.
Sir, is this an MPD trained neck restraint?
No, sir.
Has it ever been?
Not to my neck restraint, no, sir.
Lieutenant Merzel was also asked when it is the right time to stop using force to restrain someone.
Once the subject is handcuffed and compliant or not resisting, is the officer to remove their knee?
That would be an appropriate time.
Now, you should know that directly contradicts the defense argument.
Derek Chauvin did exactly what he had been trained to do over the course of his 19-year career. The use of force is not attractive, but it is a necessary component of policing.
Several other officers from Chauvin's department have also said under oath that what Chauvin did was clearly a breach of policy. Take a listen to this lieutenant with more than 25 years on the Minneapolis force.
Pulling him down to the ground, face down, and putting your knee on the neck for that amount of time is just uncalled for.
And the chief of police, the man who fired Chauvin, he had this to say.
To continue to apply that level of force to a person proned out, handcuffed behind their back, that in no way, shape, or form is anything that is by policy, is not part of our training, and it is certainly not part of our ethics or our values.
And late today, the prosecution called an expert witness on the use of force who's a sergeant in the LAPD. Take a listen to what he had to say.
Based upon your review of these materials and in light of the Graham factors, what is your opinion as to the degree of force used by the defendant on Mr. Floyd on the date in question?
My opinion was that the force was excessive.
I want to bring in now our first guest, Daniel Herbert. He's a former Chicago police officer, one-time Cook County prosecutor, and now he's a criminal defense attorney who has represented hundreds of police officers over the years. Your perspective so far in this case, specifically given the video that has been shown time and again here of that 9.5 minutes, and some of the testimony to this point that the prosecution's laid out, including a lot of folks involved in law enforcement, including senior.
I think the case is going in really well for the prosecution. They've had the ability to call a number of on-the-scene witnesses, and essentially they can call all of these witnesses because of the fact that the defense has made the crowd a central issue in this case. And what that does is it allows the prosecution to really replay its greatest evidence, which is the videotape in this case. And the last couple of days, I thought, have been some of the most compelling testimony from the witnesses that are members of the Minnesota Police Department, specifically the chief of police. I thought he was very effective.
If you are representing Officer Chauvin, what would concern you most? The duration of the tape and how long it lasted and how long his knee was on his neck? That the crowd seemed to know innately that this doesn't look right here, we got a problem, you know, at least check the guy's pulse, or that this is in broad daylight, you got 3 officers, the guy secured and on the ground. What would be the hardest for you to argue for your client given the circumstances that the jury will see for themselves?
Well, in short, yes. Every one of those points are very damaging information. You know, this scene, I've equated it more to a Norman Rockwell setting than a very tense setting. It's a sunny, relatively pleasant afternoon. There doesn't seem to be a lot of criminal activity going on. The videotape, the length of it is horrific, and the fact that everyone in the crowd seemed to recognize what was happening was excessive, and then just to see kind of the life drained out of Mr. Floyd, it's just a very difficult video to watch, and it's going to be a difficult case to defend.
You know, Daniel, I always try and say, well, if I'm sitting on the jury, what's going through my mind here? And everybody brings their personal experiences. For me, the cops have been really good in my particular life. A couple times where I've needed help, they were there. In one case, really showing real heroism. So I understand people's willingness to give the cops the benefit of the doubt, but sometimes I think this one size fits all that, hey, it's a really tough job, you know, try and walk a mile in these guys' shoes. And I think of, for example, the Ferguson, Missouri case. Michael Brown was not, in my view, some, you know, victim that wasn't foreseeable when he went to go reach for a cop's gun, that you might have seen a tragedy come out of it. But this is completely different, and attempts to equate all police incidents where deadly force is used as one and the same, I think it's a real disservice. And I think if the defense goes down that road, I think the jury knows better.
I would agree with you. You know, as a matter of fact, when I first saw this videotape, I was prepping an African-American police client, and ironically, he looked at it and thought that some of the actions were justifiable. And it was, you know, it kind of blew me out of the water, because I thought it was, you know, completely indefensible. Yes, you know, the prosecutors and specifically the defense, they have to focus on the element of criminality. They have to focus on the police having to use force in situations so that we have a civil society. But at the end of the day, you know, this case, I think that it's going to be difficult for the jurors to give Mr. Chauvin the benefit of the doubt here. And, you know, quite frankly, the easy decision to make here is guilty. I mean, there's been so much pretrial publicity and so much animus towards Mr. Chauvin that really would take a exceptional juror, and I mean that exceptional from certainly not the norm, to be very strong-willed and stick to his or her opinion in this case.
He's looking at 3 charges, and you're the right guy to talk about this. I mean, you've worn every hat, from being a cop yourself to being a prosecutor and now as a defense attorney. Which charge do you think fits best between second and third degree murder and the manslaughter charge?
Well, I think third degree, if you look at this case and you take both sides into consideration, I certainly think that third degree, the elements there match the facts of this case the best. And the prosecution certainly recognized that as they went to great lengths to include this charge. The second degree case, I thought it might have been a bit of an overcharge, but with some of the testimony that they received yesterday and today, specifically from the supervisors in the police department, that really does speak towards a finding for second degree murder in this case. Clearly, Mr. Chauvin, did not wake up that morning and intend to kill George Floyd. So it's difficult to show that premeditation or the intent. But if the prosecutors are able to show that Mr. Chauvin's actions were not regulated by the police department, authorized by training, then they can show the intent to not commit a lawful detention, but in fact, an assault. And if the death results from that assault, then clearly they can prove second degree in this case. Causation is obviously the most important element, I think, that the defense needs to attack in this case.
Dana Herbert, I appreciate the time today. Thank you so much.
Thank you.
Now, coming up next, the FBI, they've arrested hundreds of the Capitol rioters using high-tech and surveillance. It's effective to catch the bad guys, but it is also raising real privacy concerns and talk of Big Brother. After the break, I will be speaking with the Washington Post reporter who's been digging into this story.